So what document does my buyer sign to become a customer? That was a recent question that I was asked. Stay tuned, watch this video, and we're going to talk all about the customer relationship with respect to buying and selling real property in Georgia. Thank you guys so much for watching. I'm Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. And today's contract tip is all about the customer relationship. When you have a public person that wants to be your customer, what do they sign? How does that happen? They want to buy or sell real estate. What is all of that about? So I'm mainly going to focus on a buyer wanting to be your customer of your broker rather than a client. So stay tuned to the end. I'm going to give you some license law and some contract tips, and I hope you enjoy this video. So by default here in Georgia, a public person working with you and your broker to buy or sell real estate is your customer. There is nothing that is required by license law for them to sign to establish or create the customer relationship. Now, if that public person wants to be your client, then they are required by Georgia law to sign a document that creates the client relationship. In other words, for the purchase and sale of real property here in Georgia, the client relationship is contractually driven. And based on Georgia law, Official Code Georgia Annotated 10-6A-1, state law prohibits a broker from representing a buyer or a seller as a client without first entering into a written agreement under that law. So by default, if a public person chooses to work with you as the agent and thereby your broker without signing a seller brokerage agreement or a buyer brokerage agreement, they are your customer. So what does all of that mean? Well, what that means is you as the agent, you may perform ministerial acts. So when you're working with a customer, you may perform ministerial acts as opposed to if they are your client, you have a fiduciary relationship with them. Okay, lots of words, Dana. Blah, blah, blah. What does all of that mean? Well, Georgia license law 43-40-1, subparagraph 5.1 defines ministerial acts as those acts related to real estate brokerage activities which a licensee or a licensee's employee, i.e. an assistant, performs and which do not require the discretion or the exercise of the licensee's own judgment. So you don't have to have a real estate license to perform a ministerial act. You do still have to be open and honest, and you can still perform customer service type related activities such as identifying vendors that buyer or seller might choose to work with, like inspectors, lenders, closing attorneys, home warranty companies, things like that. You may identify those and help facilitate that process as a ministerial act without guiding them, advising them, so forth and so on. Now, if that public person is your client, then you have a fiduciary responsibility. So what does that mean? Well, under Georgia law, a fiduciary duty exists when a person places their highest level of confidence or trust in another person regarding a particular transaction or financial affairs, and the other party accepts that confidence or trust. So that is the definition of fiduciary. It's a little of a fiduciary relationship. It's a bit different, however, in real estate, because by virtue of you having a real estate license issued to you by the state of Georgia. You don't have, I'm not quite sure how to say this. You don't have the same type of relationship that a public person has, for example, with an attorney, in terms of confidentiality. So what do I mean? What I mean is, because you have a license issued to you by Georgia, you may not conceal material knowledge about the property that you have knowledge of, even if directed by your client. So, for example, let's say, I don't know, let's say you're listing a house and there is evidence of a huge water leak and in the basement, and you talk to the seller and the seller says, yeah, there's a leak there, but I'm going to put this big old huge 5,000-pound gun safe in front of it. No one will ever know. The buyer will never know. Shh, don't tell. Well, as a real estate licensee, you are not allowed to keep that secret, because now you have specific knowledge of a material defect about the house that the seller is attempting to conceal. And it's not that it's that easy for a buyer in the normal course of reasonable inspection to move a 5,000-pound gun safe to see that. So that's a little bit different, as opposed to where it's just a little bit different in real estate. So back to the question at hand. So what about a customer? Well, there is nothing in Georgia law that requires a customer to sign anything to become a customer. They automatically are a customer. Now, your broker may have a policy on that, and I highly suggest that you make sure that you have your public customer sign a document that describes the customer relationship. So the seller brokerage agreement and the buyer brokerage agreement create the client relationship, but there are customer acknowledgments that describe the customer relationship. So in GAR, if you are working with a buyer as a customer, there is the Georgia Association of Realtors Form F116, Agreement to Work with Buyer as a Customer. And that describes the customer relationship between your public buyer and your broker and you as the affiliated licensee. If you are working with a buyer who wants to stay as a customer, in the RE forms, it is RE Form 159, Acknowledgement of Customer. If you are working with a seller and they choose to stay your customer, in the GAR, Georgia Association of Realtors Form, I highly suggest they sign GAR F107, Authorization to Show Unlisted Property. That describes the customer relationship between them as the public seller and your broker. And likewise, in the RE form, it is RE 158, Seller's Authorization to Show Property without a listing agreement. Now, how does this impact the actual real estate transaction? Well, if you are working with a public as a customer, then you notice regarding the notice section, notice if you're working with the public as a client, then notice to the agent or the broker serves as notice to the client. If you're working with a public person as a customer, then in terms of notice, as outlined in the notice section of the contracts, and in the GAR purchase and sale agreement, that is outlined in the notice section, paragraph C1, and in the RE forms, that is also outlined in the standard terms under the notice section, paragraph 11. Notice, when you're working with a customer, you must send notice directly to that customer. In addition, as professional relationships go, to the agent working with that customer. So on the signature page, if you're working with the public as a client, you do not need to disclose their email address or fax number, but a customer you would. Now, your brokers need contact information for your clients, but you don't need to put that on the purchase and sale agreement. but you do in terms of working with a customer. Now, additionally, if a public person has chosen to work with your broker and you as a customer, you co-op agents, that does not give you permission to cross-assign. That public person has still chosen that agent and that brokerage with whom to work. It doesn't give you free rein to communicate directly with them without going through their agent or their broker. It's just that the legal nature of their relationship is that of customer rather than that of client. But it's not a free-for-all to totally ignore the agent with whom that public person has chosen to work. They've just chosen to be their customer. And one more thing to keep in mind is Georgia License Law, GREC Rule 520-1-.064B states that if you are working with the public in a client relationship, a licensee shall provide written disclosure to both buyer and seller, revealing the party for whom the firm is acting and from whom the firm will receive valuable consideration for its efforts as agent in the transaction. If the licensee firm is not acting as an agent for either party, i.e. working with the public as customers, then the licensee shall make a written disclosure revealing from whom the licensee's firm will receive any compensation for its efforts in the transaction. The written disclosure required by this paragraph, License Law GREC Rule 520-1-.064B, the written disclosures required by this paragraph must be made in a timely manner, but in any event not later than the time that any party first makes an offer to purchase a property. So there is a lot to working with a public person as a customer as opposed to a client. Additionally, if that public person has questions and wants to become a client, GAR has a consumer brochure, which is the GAR. Let me find it for you. It is the consumer brochure CB01, the ABCs of Agency, Understanding Real Estate Brokerage Relationships in Georgia. I highly suggest check with your broker on your broker's policies, but I highly suggest that you get this document into the hands of your public person who does choose to be a customer, as it does describe the differences, what a client is versus a customer, and the duties and the responsibilities of the brokerage and the agent working with them in that capacity. So I hope this contract tip helped you out and helped explain a little bit about what documents are available to you as the agent to create the client relationship, should your public person choose to be a client, and to describe the customer relationship should your public choose to remain a customer. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.